Warm greetings everyone. I'm Dr. Purnima Khanna from Khalsa College of Law, Amritsar. My dear learners, today we will learn about a very important topic, that is nullity of marriage under Hindu law. The learning outcomes of the present module will be firstly, introduction, secondly, grounds for a void marriage, thirdly, grounds for avoidable marriage, then difference between void and voidable marriages, and finally the conclusion. Let's begin with the brief introduction about the topic. Nullity of marriage means the cancellation or repudiation of a marriage. A valid marriage results in the legal marital status of the parties, their mutual rights and duties, the legitimacy of children, and the right to inheritance. The present module deals with the concept of void and voidable marriages under Hindu law. First of all, let's discuss what are void marriages. A void marriage means a marriage that has no legal status in the eyes of law. Hence, it will have none of the legal consequences that a valid marriage has. As per the provisions of Section 11 of the Hindu Marriage Act 1955, the grounds for the void marriages are as follows. Bigamous marriage. Section 5, Clause 1 mandates monogamy as the first condition of a valid Hindu marriage for all Hindus. If a Hindu is married and his or her first spouse is living and marriage is subsisting, a second marriage cannot be performed. In the event that such a marriage is performed, it will be bigamous marriage and void ab initio. Then, marriage within prohibited degrees of relationship. According to the third condition, parties cannot marry with prohibited degrees of relationship. The list of such relationship is laid out in Section 5, Clause 4 of the Hindu Marriage Act 1955. However, in accordance with the exemption to the rule, such a marriage will be legal provided the parties' cultural traditions permit it. In Shrimati Shakuntala Devi versus Amarnath, 1982, it was pleaded that there existed a custom amongst Aroras in West Pakistan that allowed marriage between the children of a brother and a sister or two sisters, and that after migration to India in 1947, this custom still continues to prevail amongst them. Aroras do not belong to the orthodox class of Hindus and were known to be much more liberal about the prohibited degrees between the two spouses. The said custom was upheld by the court based on the oral evidence produced by the appellant. Next is marriage within spindas. A marriage performed within 5 degrees of relations from the father's side and within 3 degrees of mother's side, parties being spindas to each other, is a void marriage in violation of the 5th condition laid down by Section 5, Clause 5 of the Hindu Marriage Act 1955. Dear learners, let's understand the status of a void marriage. Duncan Derrett very aptly observes that it is essential to remember that void marriages are marriages that in the eyes of law never took place. No subsequent events are being able to cure their defects. Without such a decree, which is merely of a declaratory nature, the parties may marry again or behave exactly as if the alleged marriage had never happened. However, only aggrieved parties have locus standi. Section 11 can be invoked by only those persons who are parties to a marriage, as would clearly appear from the words either party thereto used therein. The relief of declaring a marriage void has been intentionally confined to the parties to the marriage, and it is not open to any other person to make an application under section 11. As far as the burden of proof is concerned, in Surjit Kaur versus Jujhar, 1981, where a husband filed a petition for a decree for nullity of marriage on the ground that the former husband of the wife was alive at the time of marriage. It is for the wife to prove the death of her former husband to successfully resist the petition. And on her failure to prove the death of her former husband, she would have to face a decree for nullity of marriage. Let's discuss the inheritance rights of children born out of a void or voidable marriage. A child born of void or voidable marriage is not entitled to claim inheritance in ancestral coparcenary property, but is entitled only to claim share in self-acquired properties, if any. Therefore, the question of inheritance of coparcenary property by the illegitimate children who were born out of the live-in relationship could not arise. Next is voidable marriage, which are discussed under section 12 of Hindu Marriage Act. A perusal of the first clause of section 12 highlights that this section has retrospective operation. Hence, any Hindu marriage performed before or after the commencement of the Hindu Marriage Act 1955 may be annulled at the instance of the aggrieved party on the basis of 4 grounds. Firstly, impotency. According to section 12, the essential ingredients of the ground of impotency are as follows. Firstly, the couple has not yet consummated the marriage. Consummation was not possible due to the impotence of the respondent. It is to be noted that impotency may be due to some physical deformity or some mental or psychological impairment. My dear viewers, there is a difference between impotency and sterility. The concept of impotency under the Hindu Marriage Act 1955 is different from the vast concept of impotency under medical science, which sometimes includes sterility as well. A male with no or a low sperm count, or a female who is barren and unable to conceive may be impotent as per medical science. However, if such a male or female is able to perform sexual intercourse, they will not be considered impotent under the provisions of the Hindu Marriage Act 1955. A person may be incapable of accomplishing the sexual act and yet be capable of procreating. Conversely, the person may be incapable of procreating and yet be capable of accomplishing the sexual act. Hence, the concept of impotency under the Hindu Marriage Act 1955 does not include sterility. Sterility alone, however, is no ground for holding the marriage voidable or declaring it a nullity. What is the importance of curability of impotency? In a pre-independence case, Bishwas versus Bishwas, 1921, the court observed that impotency connotes incapacity to cohabit, whether it be physical or mental, but it must be permanent and incurable. However, after the amendment of 1976, as per section 12 clause 1, it is not relevant that the impotency shall be curable for the purpose of annulment of the marriage on the ground of impotency. In Lakshmi versus Babulal, 1973, the court stated that sterility is different from impotency and that a sterile person is not necessarily impotent. The ability to procreate children is not a necessary ingredient of potency. Impotency in matrimonial cases has been understood to mean incapacity to consummate the marriage, that is, incapacity to have conjugal intercourse, which is one of the objects of the marriage. Dear viewers, let's understand the meaning of consummation. Consummation of marriage means full and normal sexual intercourse between married persons after their marriage, irrespective of whether conception is effected, precluded, or impossible for any reason. Where the former impotent spouse is operated upon so that it is probable that normal intercourse may take place in the interval between the commencement of the proceedings and the hearing, the judge has discretion to refuse the decree. In Momita Roy Chaudhary versus Abhijit Chaudhary, 2014, the court held that the wife is entitled to annulment of marriage if the marriage is not consummated due to the impotency of the husband. As far as the burden of proof is concerned, the onus of proving the existence of the condition of the respondent spouse being impotent not only at the time of marriage but also about continuing to be in the same condition even at the time of institution of the petition would lie heavily on the petitioner spouse. The impotency of the respondent can be proved either by medical evidence or by the corroborated testimony of the petitioner. Potency is to be presumed and the party alleging impotency is under a legal obligation to prove the same. Impotency may be established by a medical examination of the parties. The doctor who examined either party or both parties may be examined as a witness. Next is unsoundness of mind. Section 5 provides that a marriage may be solemnized between any two Hindus if the conditions specified in the section are fulfilled. Amongst the other conditions stated therein, in subsection 2, it is laid down that at the time of marriage, neither party is incapable of giving a valid consent to it in consequence of unsoundness of mind, or though capable of giving a valid consent, has been suffering from a mental disorder of such a kind or to such an extent as to be unfit for marriage and the procreation of children. The clause lays down as one of the conditions for a Hindu marriage that neither party must be suffering from unsoundness of mind, mental disorder, insanity, or epilepsy. And section 12, clause 1, subclause B refers to the fact that any marriage shall be voidable and may be annulled if the marriage is in contravention of the condition specified in clause 2 of section 5. On a plain reading of the said provision, it is manifest that the conditions prescribed in that section, if established, disentitle the party to a valid marriage. The marriage is not per se void, but voidable under the clause. Such conditions, in the very nature of things, call for a strict standard of proof. The onus of proof is very heavy on the party who approaches the court for breaking a marriage already solemnized. In Ram Narayan Gupta versus Shrimati Rameshwari Gupta, 1988, the appellant husband filed a suit for dissolution of the marriage, alleging that his wife was suffering from severe mental disorder, psychiatrically recognized as schizophrenia, which rendered her unsociable, and despite competent professional treatment, her condition deteriorated to the point of making manifest in her suicidal tendencies and aggressive violent behavior towards others. The appellant could therefore not reasonably be expected to live with the respondent as a man and wife. The respondent's wife denied the imputation of insanity and contended that appellant was determined to get rid of her as a result of the domestic discord between her and the appellant's mother and sister. The respondent wife produced a copy of the order passed by the magistrate in proceedings initiated by the appellant husband under the Indian Leniency Act 1912, that there was no abnormality in her requiring institutional treatment. The High Court held that the appellant had not shown that his wife's mental illness was so intense as to justify a reasonable apprehension that it would be impossible or unsafe for the appellant to live with her. The Supreme Court, while dismissing the appeal of the husband, observed that the mere branding of a person as schizophrenic will not suffice. As far as the burden of proof is concerned, if a party to marriage files a petition for annulment of marriage under section 12(1)(b) on the ground of insanity of the other spouse, the burden of proof lies upon the petitioner. Though the burden of proof lies on the petitioner to prove that respondent is suffering from recurrent mental disorder and insanity, the standard of proof is only to the extent of preponderance of probabilities. Proof beyond reasonable doubt is not required. Next ground is consent by force or fraud. The law prior to the amendment was strict and provided that if a person willingly consents to being married under the Act to another party in accordance with customary ceremonies, the marriage cannot thereafter be challenged on the grounds of fraud. The current law stipulates that neither force nor fraud can obtain the consent of the parties to a marriage. If a party obtains their consent through force or fraud, they can apply for a marriage annulment within a year of the force ceasing to operate or fraud's discovery. What is force? Where the will of one of the parties has been overborne by genuine and reasonably held fear of the threat of immediate danger, for which the party himself is not responsible to life, limb or liberty. The constraint destroys the reality of consent to wedlock. In Velayuyadam versus Kannagi, 1991, a low caste girl was seduced by a high caste boy, and the community gathered to assault the boy. The panchayat intervened and the boy consented to marry the girl. Later, the boy claimed the use of force in the solemnization of marriage. The court held that there might be coercion but not force. It is to be noted that under the Special Marriage Act 1954, the words used are coercion or fraud. However, under the Hindu Marriage Act 1955, coercion is not a ground for nullity of marriage. Now, what is fraud? The term fraud is not defined in the Hindu Marriage Act. The Allahabad High Court dealt with this question in Pradeep Kumar Maheshwari versus Shrimati Anita Agarwal and noted that it varies from one family to another, according to culture, ethos, and social system in ages and situations. For example, in a conservative family attached to Puritan society, in a marriage is inevitable, and the unerring expectation is that both the bride and the groom must not have any record of prior marriage in any sense, nor will they have any marriage in any sense, not even any premarital affairs with another boy or girl, as the case may be. They cannot even think of marrying outside their caste and community. Conversely, a family with a liberal and cosmopolitan approach, particularly in urban areas, will not mind in the case of marriage, even if they have knowledge of the background of prior marriages or premarital affairs with other people outside their caste and community. In the former, concealment of caste, community, or background of prior marriage or premarital affairs before or at the time of marriage is obviously extremely material, and it amounts to fraud in obtaining consent. Fourth ground of voidable marriage is premarital pregnancy. The fourth ground for annulment of marriage is the premarital pregnancy of the wife by a person other than the husband. The conditions for annulment of marriage on the basis of premarital pregnancy are as follows. Number 1, the wife was pregnant at the time of marriage. Secondly, the pregnancy was from a person other than the husband. Thirdly, the husband was ignorant of the pregnancy of the wife and he had no marital intercourse with the wife after the discovery of the pregnancy by some other person. It is important to remember that if husband continues to engage in marital relationships with the wife even after discovering of the pregnancy, it implies that he has approved of her premarital pregnancy. Fourthly, the husband has filed the petition for nullity of the marriage under section 12(1)(d) within 1 year of the marriage. In Baldev Raj Miglani versus Shrimati Urmila Kumari, wife of Baldev Raj, 1979, the husband filed a petition under section 12 of the Hindu Marriage Act 1955 for the annulment of his marriage with the respondent on the ground that at the date of marriage, that is October 8, 1962, the wife was already pregnant by some other man, of which he was ignorant then. The Supreme Court held that in order to appreciate the evidence on record, two crucial dates must be kept in mind, namely October 8, 1962, being the date of marriage between the parties, and May 20, 1963, the date on which the respondent delivered a fully mature son. It was nobody's case that the appellant had access to the respondent before the date of the marriage. And even according to the respondent's case, the sexual relations between the two commenced on October 9th, 1962 and did not last beyond October 30, 1962. In other words, according to the respondent, the pregnancy, if it was as a result of sexual relations with the appellant, could commence not earlier than October 9, 1962. The decree passed by the division bench of the High Court was set aside, and that passed by the trial court in favor of the husband was restored. Now let's talk about the burden of proof. The petitioner has to establish such facts and circumstances that would lead the court either to believe that the respondent was pregnant at the time of marriage by someone else, or to hold that a prudent man would, on those facts and circumstances, be completely satisfied that it was so. No petition for the annulment of the marriage shall be entertained unless the court is satisfied that the petitioner was, at the time of marriage, ignorant of the facts alleged and that no marital intercourse with the consent of the petitioner has taken place since his discovering the existence of the grounds for the decree. Dear viewers, let's discuss about the consequences of nullity under Section 12 of the Hindu Marriage Act 1955. Direct describes that when a marriage is annulled on any ground specified in Section 12, the marriage becomes void ab initio. But until that step is taken, a step within the exclusive province of a court of competent jurisdiction, the marriage is valid. Such a marriage will have all the legal attributes of a valid marriage under the Hindu Marriage Act 1955 until it is nullified by the court of competent jurisdiction. Let's have a brief overview of the difference between the void and voidable marriage. Section 11 of the Hindu Marriage Act 1955 provides the grounds for a void marriage, while Section 12 provides the grounds for a voidable marriage. A void marriage is void ab initio, and it does not require a declaration of nullity from a court of competent jurisdiction. Conversely, until a court of competent jurisdiction issues a decree of nullity, a voidable marriage remains valid. In a void marriage, the court simply declares the marriage null and void. In voidable cases, the court annuls the marriage through a nullity decree. Parties to a void marriage are free to remarry, whereas in a voidable marriage, a second marriage cannot take place until the voidable marriage is still in effect. Further, a wife has no right to claim maintenance in a void marriage. On the other hand, in a voidable marriage, the wife has the right to claim maintenance. Dear viewers, on the basis of foregoing discussion, we may sum up that the Hindu Marriage Act 1955 under Section 5 lays down certain conditions for the performance of marriage under Hindu law. A violation of these conditions may lead to a marriage being void or voidable. It is clear that a void marriage is void ab initio, and it does not require a declaration of nullity from a court of competent jurisdiction. Conversely, until a court of competent jurisdiction issues a decree of nullity, a voidable marriage remains valid. With this, we come to the end of today's lecture. Thank you very much.